My name is Kaka.
Dated the 14th of May 2025, whereby we do note that there are two subsisting petitions before the High Court touching on the insolvency status, to read insolvency notice number E012/2019, E012/2019. Insolvency notice number E008/2019. You know that the issues allegedly under investigation, we believe are well off being conversed in the insolvency petition court. And the same issues stem from management functions that are performed unlawfully. You know that these functions find as the Office of the Director of Public Prosecution that the contentious issues have been addressed substantially in the two petitions. Consequently, Your Honor, we do find that there is no criminal culpability that can be deduced from this particular matter hearing before the court. And that the same will be addressed through civil redress. Your Honor, as the Office of Director of Public Prosecution, we are guided under Article 157(2) of the Constitution in averting the abuse of criminal process. And in the circumstances, Your Honor, we do wish to withdraw the same under Section 87A of the CPC. That the court to consider our application, Your Honor.
They are abusing the process. They are the ones abusing the process. And their powers under Article 157, they are not acting in the public interest and in the interest of administration of justice. In fact, the reason offered, respectfully, the reason offered by the learned DPP, I would just short of calling it inept. If you look at the charges, they concern conversion of 3 motor vehicles from the administrator appointed to oversee the company. There is a very elaborate process of arriving at a decision to prosecute under the National Prosecution Policy. We haven't heard our learned friend say when they reached the Damascus movement and decided to change tact. Actually, even reference to the insolvency petition is totally misguided. For good order, the administrator was interrupted in his exercise of the duties and is a witness and is also the complainant before court. If you look at the pattern of DPP in this matter, it has been wanting. And if you look at your record, on 30th of January last year, 2024, a similar groundless application was made, which led to the discontinuation of proceedings. against the first accused person. That accused person. Now, at the time, what was the reason offered is that it would delay the expeditious prosecution of the case. The third accused person, and I say this, is the one who conspired with the first accused person to, according to the charges, to convert the 3 motor vehicles. Yona, what is most sad is that today being 11 on 9th, a pre-trial was held with the witnesses who are in court today. They are present before court, ready to testify. But if you hear from my learned friend from the prosecution, this letter is alleged to have been issued on 14th of May, meaning that she was not privy to that decision. Similarly, the investigating officer never told us that there is any such decision. You know, when the decision to withdraw the charges is made and there is a victim, in this case the complainant, respectfully that person should be informed and also given the reasons. This cavalier and casual way of interfering in the criminal justice system, it is starting from the National Police Service. The court can take judicial notice of the events happening in the country. And the worst thing is that it is also going to the office of the DPP. With all due respect, the current holder of the office must also be stopped from extending the abuse of criminal justice system. Apart from being incompetent, he's coming to shield suspects from facing justice. It is not for us in this matter to discuss whether he should be impeached, but this is a clear case of somebody whose sole mission on earth is to defeat criminal justice system. We have suffered on that day of January 2024, and people say lightning does not strike twice. Here it has struck again. Yona, we tender 3 decisions. We are always armed with them because the DPP this is the biggest threat to the criminal justice system. And I'd like particularly to rely on the second decision by Lady Justice Mother Kome. That is the case of Republic versus Enoch Wekesa. I've flagged it for your honor. And the primary consideration should be the interests of justice and public interest. And she found that the ODPP cannot just casually wake up and withdraw criminal cases and defeat the cardinal rule that there must be justice for all. We do not want to speculate what may have happened behind the curtains. That is beyond us. But we urge Your Honor to stand firm. We have cited 3 decisions. And in all circumstances, the court stood firm, and particularly the first 2 cases, Ahmed Rashid versus DPP and DPP versus Enoch Wekesa. I'm sorry to say the witnesses are present in court. I think my learned friend is appearing in this matter for the first time. Mr. Kaka, I do not want to insinuate anything. I believe he was just the beneficiary of new instructions. We urge you to stand firm. Who will protect Kenyans other than the courts? Who will protect Kenyans from the abuse of office by the National Police Service? Who will protect Kenyans from abuse of office by constitutional bodies such as the ODPP? Your Honor, you have the answer. The witnesses are present. Just to finalize this matter, there was even accused 3 whose case was withdrawn again by the ODPP, had even been ordered to be extradited to Kenya. Such is the faceless and gross insensitivity of the ODPP that a witness whose the UK government had agreed to extradite to Kenya, they gave him a golden ticket to fly away. Just when we've caught the bird, they removed the trap. What role are they doing in this matter? They are tinkering with the justice system. They are bringing down the Republic of Kenya, and we urge you to dismiss this request. The prosecutor was not even kind enough to say she has 2 witnesses in court. I'm sorry, I'm embarrassed to say I'm the one saying they are present, and I request them to stand so that it doesn't appear to be a casual reference. They were prepared. These are people who are also seeking justice. He is the administrator, PW1, the complainant. Today would have finished with 25% of the case of the witnesses. What is the ODPP fearing? What did they find that made them? My humble submission is that it's not an accident. It's a treasure hunt, this one. But these are competent witnesses. They cannot be interfered with. They'll be able to explain their case. And about this debate, most of them don't.
With your kind permission, I wish to state that justice is a double-edged sword. The accused too has rights that needs to be protected. Your Honor, as I had stated, I am very, very new in this case. I was only instructed to come on board in this matter. And I have heard my colleague here, who is my very good friend, citing some authorities. I have not had occasion to look at those authorities. If I was given an opportunity, I would have responded better with the same. If the office of the ODPP does not receive instructions from any other source, it is an independent organization that determines what to take to court or what not to take to court. That does not mean that the complainants are completely locked out. Our laws are very, very clear that they still have an opportunity if they feel so much aggrieved, and they can even still go by way of private prosecutions, that their rights have been denied in any way. As informed by the prosecution, they have reached a conclusion, and they have presented their conclusion to the court. But my position is that if the court is really minded to entertain their application, let us then all be given a time to look at their to look at their complaint, look at the authorities, and then I will be in a position of presenting on behalf of my client a response that serves him justice. Lastly, we enjoy ourselves and we have no problem with the office of the ODPP determining that they do not wish to proceed with these proceedings as they are. That will be all. Thank you.
CPC, which is not absolute for the DPP. It has to be there with the permission of the court. Since there's an opposition to the withdrawal, we'll have to hear both sides, then the court will make a ruling on the determination whether the withdrawal is justified or not. I believe we've made a fair request to be supplied with the authorities which have been cited by counsel watching brief for the complainant. The same can be supplied to you, then we can agree. We come back, we canvass our arguments, then we can have a date for ruling for the court to make a determination. For one reason, it has never proceeded, so we need to iron out the issues and agree on the way forward.
We have tentatively agreed the 15th of July.
Yes, then in that case, if it's the 15th of July, I'm going to with the authorities today. 15th of July is about 1 month. So yes. Then file submissions. So on the 15th of July, I'll be confirming that you have filed the submissions to their application. Then I'll give a date for ruling. Because I was thinking of taking a mention date for you just to confirm that you've been served with the authorities and us to have like oral submissions. But if you're taking it to a month, I believe that is a bit too long. So I can say you put in written submissions, you are served with the authorities today, then you put in written submissions.
On my part, I have no problem. I could file written submissions. I think they are better so that when you then come, we don't have to take much time submitting on oral. I think written submissions would suffice. And I think then, because he is the one who is opposing, he should first of all serve us, then we respond, and then the
already submitted.
The submissions, the written submissions.
You can respond to yours.
No, if they are not going to file any submissions, I have no problem. I can file, but if they are going down to file submissions, then the proper order should be they file. Then, because now we are now responding to their submission of them.
I was thinking that they have already submitted, and even given the authorities, it's because we did not have the authorities, we are not able to submit. So the submissions were coming from your side, unless they are saying they wish to put in any further submissions.
No, we can only respond. They have to theirs, but now they are together. Can only respond.
Very well, very well. We stand ready. Thank you.
Be supplied with the authorities by the counsel watching brief for the complainant to enable the defense put in their written submissions. We'll have the matter mentioned on the 15th of July to confirm submissions have been filed by the defense and take a date for ruling. Once the defense has filed their written submissions, they can have the same served upon the counsel watching brief to enable them to file any supplementary submissions if need be.
Yeah,